Hi, and welcome to another edition of the Trustcast Show. And I'm pleased to have with us today Thomas Patterson. Tom, welcome to the show.
Thanks for having me.
So today's guest is a Chicago trial lawyer whose boutique firm won a $32 million malpractice verdict against the self-proclaimed largest law firm in the world, the biggest legal malpractice judgment in Ohio history. Tom Patterson has tried roughly 100 cases. Did I say it was 32 million? Wow. Tom has tried roughly 100 cases, wrote the ABA book on business emergencies, and just published a 720-page biography of Huey Long that won the Landry Press from LSU Press. So you said for law school, or you paid for law school. The print as I get older, they make it smaller and smaller. The fonts, they make them smaller. So you paid for law school by working as a straight commission salesman trained in Xerox sales techniques. How did that shape the trial lawyer you became?
Well, I think the sales techniques that they tell you to use have certain parallels in the legal profession. So a salesperson will use non-directive questions to probe a prospect. Like they might say, "Oh," or if the prospect says it's a nice day out, the salesman might say, "Is the nice day out?" just to get the prospect to talk. And so in depositions, as a lawyer, I will sometimes use pauses or silence to draw out the witness if I want them to start talking. And then the salesperson will also have directive probes, like, do you think this product costs too much? And you have those in depositions as a lawyer as well. And then when you get into court and you're arguing about a case, a salesman faced with an objection, if it's an easy objection, like you think it costs too much, you think it costs $3 a unit. No, it actually only costs $2.50, and it's cheaper than all the rest of the products on the market. That's a rebuttal of a direct question, direct rebuttal. If it's a more difficult objection, you restate the objection, minimize it, and stress other relevant benefits. And so, if I said, well, this pen, you think this pen costs $2, well, yes, it costs $2, but look, it's more comfortable. The ink lasts longer and it presses harder and it's easier to write with and so on than any other comparable pens on the market. And you use a similar discussion in front of a judge. If he says the Acme case is against you on it, I'll either say, no, the Acme case ruled in my favor, or I'll say the Acme case said this, but other cases said this, this, and this, and that's how I'll argue the case. So you can see how some of the communication techniques of a salesperson do translate into being a lawyer.
I know years ago, I was selling photocopiers as a very young man. And Xerox, I remember at that time, had a very formidable training program. It was really highly respected. So you clerk for Illinois Supreme Court Justice William G. Clark right out of law school. What did watching the system from the inside teach you about winning?
Well, it was fascinating to be involved with the judges as they discussed a case or as they heard lawyers argue the cases and then how they reacted to those arguments of the lawyers. So that was priceless education. And the judge I worked for had been a legislator, had been a state senator, he had been attorney general. He is probably the only justice in Illinois history who had served in all three branches of government. And so he had all these stories about prior politicians, prior events, campaign stops. He was on a campaign stop once on a boat down the Mississippi, and the boat sprang a leak, and he had to conduct the musicians as the people were exiting the boat. He made the press get off last. I guess that was
that makes sense.
Yeah.
So after years at larger firms, you launched your own shop in 2000. Is that right?
Yes.
And what was the breaking point that made you say, I have to do this on my own. I need to do this differently.
Well, that's what it was. I thought I want to do things differently. I thought I had a lot of ideas that I thought the big firm wasn't using. And when I spun off into a smaller firm, they weren't using them either. And I thought, gee, I can do better. And I was tired of blaming partners for not taking actions that I thought were worthwhile. And so then I figured, well, I better do it myself. Then I have no one else to blame, and I can do what I want and don't have to talk to people about what to do, and do it. And I would say about half of the time I was correct, and that I did have improvements, and the other half of the time I found, well, that wasn't such a great idea, or there was a reason behind the firm doing this, that, and the other instead of what I wanted the firm to do.
So, what was I know I'm going back quite a ways, but what was the first week like?
Well, I'll tell you, it was very interesting to start your own firm, and you've got everything in your head. You don't have to have a lot of systems and things like that. You know what you've made to the penny, and you're carrying it around, in your checkbook. And so I remember calling potential clients and clients that I'd actually worked for after I left the firm, and asking them if they wanted to go with me. So the first client I talked to, he said, "Yeah, sure, I'll go out with you, of course. Let's congratulations on starting your own firm. That's terrific. And how many people are you starting it with?" I said, "Well, myself." There was a pause, and they said, "Well, okay then, I'll still go with you." And so I remember that, and it was quite
Wow. Yeah.
a shot of confidence for me.
Yeah, that is great. That's a good story. So you describe yourself as a D and C on the DSC profile, driven to get results and obsessed with accuracy. How does that combination show up in a trial?
Well, I think in a trial, you have to look at things in the detail and in the big picture. And so if you can't get your documents into evidence, you're foregoing an important detail for your case. So you need to be detail-oriented, precise, disciplined, and so on. And then you also need to step back and see the big picture. Not every detail is going to resonate with the jury or even necessarily be understood by a jury. So you have to have the big picture, consider your themes, consider what trial lawyers call the rules of primacy and recency. So the first thing you say at the start of every day, the last thing you say at the end of the day are going to be remembered by the jury more than a lot of the stuff that happens in between time. So you want to start strong, you want to end strong, and then you want to have all the details wrapped up in the meantime. And the details are important not just for the jury trial, but to make sure that you've protected the record in case you have to appeal. So that Ohio case, they took an appeal to the Ohio appellate court, and the court issued a 55-page opinion. But all the details were wrapped up, and so the court affirmed the verdict.
Wow. So tell me about what was that? Explain to me how that case turned. What were the key points in that case?
I think it was a David and Goliath situation. We represented a small family business that was taking on a very large law firm that had a conflict that caused it to be disqualified right before an important hearing before the International Trade Commission. And the client itself had patented this unique process for laser abrading blue jeans. And I don't know if you know familiar with the ripped look of blue jeans or the faded look of blue jeans, right? Well, they used to have those blue jeans created in third world countries by sandblasting them. And so all these third world workers were getting silicosis from the sand.
Mm-hmm.
And so our client had come up with a great laser process. And so you'd put, for example, blue jeans into this chamber and it would rotate and the laser would be applied and you'd see the jeans smoking as the pattern was being lasered into the jeans. And then you'd pull the jeans out and they were ready to sell. Well, everybody was infringing on that patent. They arranged some financing to pay a law firm to seek a general exclusion order from the International Trade Commission. And right before a key hearing, that law firm got disqualified. And they had told us that the conflicts had been cleared, and they weren't. And so we suffered substantial damages as a result.
So, at what point did you step into that mix? It sounds like a difficult. So you're suing the firm that was representing this group that came out with this innovative way to make blue jeans look a particular way.
Yeah. Exactly. But that's true of a lot of malpractice cases, right? Some other law firm screws up the underlying case, and so then you sue the law firm for screwing it up. And you have to prove a case within the case. That's what makes legal malpractice cases so interesting, at least to me, because you have to prove the underlying case that you would have won it, and then you prove that the lawyer or law firm booted the case and caused you to lose it.
So, so I talked to attorneys quite a bit, and some
I'm
of them
sorry for that. That's really,
you know what Shakespeare says about attorneys.
yeah.
So I'm sure every attorney knows. So I talk to attorneys quite a bit, and they talk about the more successful ones that they talk about. It's best to be collegial for a number of reasons within the courtroom with your adversaries. But I would think in your particular case, where you're taking on another firm, it's really difficult to be collegial. They probably hate you.
Well, it's funny. We still get significant referrals from former opponents, both the law firms or lawyers that represented an opponent, and sometimes from the opponents themselves. We try not to take things to a personal level. We try to remain collegial without giving up any significant advantage or tactic that we need to pursue on behalf of our clients. But you can do that and still be civil and professional. And I think the judges appreciate that more. You hear a lot of times clients will say, "Oh, I want a junkyard dog," or, "I want an aggressive lawyer."
Yeah.
Right? And what happens if you have to settle the case? I mean, what happens if there's some unexpected or unknown fact, that's uncovered by your opponent, not disclosed by your client to you, and then you have to settle the case? You can be a junkyard dog all you want. If you have to settle a case, it helps to have professional civil relationships with your opponent.
Well, and if
Treat
you have a
treat your enemies like they might someday be your friends, and treat your friends like they might someday be your enemies. I think that's pretty good
yeah,
advice.
and I think when you go before a jury, that I don't know how much of your caseload is jury trial versus just straight up the judge decides.
I'd say probably 30-40% is jury trials.
Okay. So when you're in front of a jury, it's to your advantage to be collegial. And I don't know, probably in front of a judge, they probably get irritated as hell.
Yeah, judges sometimes resent emotional displays more than a jury would. A jury watching TV and getting their ideas about jury trials from television probably expect you to start jumping up and down and, going berserk in the courtroom. Whereas a judge doesn't want the theater. They just want to know the facts and the law and how to make the best decision.
So how long did it take what was the discovery like in that case? The $32 million case.
It was extensive. We had depositions in Washington, D.C., New York, and as well as Ohio. So it was a long time. And the whole case took over 6 years to finally resolve.
Wow, that is a long time. Okay, let's see. So walk through when a business emergency actually looks like when someone calls your firm in a panic.
So they'll call up and say, "Well, I started this great company with my brother, and he just locked me out of the company, and he spent $400,000 on a new car, and his wife is doing the books. And what do I do now? I own 50% of the stock, but he said I can't come back into the company until I take pennies on the dollar for my shares." Right? That's a paradigm type case that would walk in the door. And so then you have to figure out, okay, well, wait a minute. First send me an engagement letter. and then send me the bylaws and the shareholder agreements and send me all the correspondence that led up to this unfortunate event. And then I'll go through what their remedies are. In Illinois, you have remedies under the Business Corporation Act, and there's similar acts in most states. And you file a case. In that particular case I'm thinking of, we had to file an emergency injunction. Hey, put the money for the car back. Don't spend any more money, and keep the status quo until we figure out who's going to own what. And after a year or two, we ended up buying the other brother out, and he left the business, and our client made a significant profit.
Wow. So when you have that kind of situation, I guess you have to. So can you take on those kinds of clients anywhere in the U.S.? You have to have so if someone approaches you and says, okay, you guys have this kind of unique experience, which it does sound like you do, and then they approach you and they're from Utah or Washington State, or I saw Washington State on your site, so you've got that one covered. But they're in some place where you haven't practiced before, Wyoming. What do you do in those cases so that you can take care of somebody who needs your kind of unique skills?
As long as we're barred and in good standing in Illinois, we can usually get admitted by permission to do at least one or two cases in any particular state. Florida is restricted. For example, you can only appear in two cases as a guest in Florida before you have to start taking the bar and get licensed in Florida. So since I'm in good standing in Illinois, knock wood as I say that, I can usually ask a Florida court or some other court to let me practice in the particular case by permission. And lawyers, of course, have some jargon for that. It's called pro hac vice, and so you get admitted pro hac in another state, and then you can litigate the case. Often, you have to have a local lawyer, which is wise to do in any event, because the local lawyer will know the judge, know the jury, veneer, and things like that.
So you offer clients a billable hour guarantee. Most law firms don't do that. So why does yours?
Well, I like talking about fees up front. I always try to keep the cost benefit to the client in mind. I don't try to file a bunch of useless motions that might be emotionally satisfying for my own client if I don't think they're going to advance their case. And so I don't like to quibble about fees. If somebody says, hey, that phone call took 0.3 and you billed me 0.4, for goodness sake, I'm not going to haggle about that. But nobody actually does that, really. In 20 years or so, I've only had one client who tried to take advantage of that guarantee, and I honored the guarantee and then separated from the client, and that was that.
Yep. So a client came to you 3 months before a trial with an $8 million guarantee case. Another firm called an unmitigated disaster. How did that end up with a zero liability verdict?
Well, I tell you, we worked very hard on it. It was a loan guarantee case, and the building had been foreclosed, and the client owed a personal guarantee to the bank. But we proved that the bank was guilty of bad faith in the administration of that loan, and that he could have repaid them had they approved the condominium sales that he wanted to sell, and that would have paid the bank off at the time. So I think that was a jury trial. It was very interesting, and it certainly taught me a lot about the banking industry. There's a big difference in the banking industry between the loan officer, who's always a hail fellow, well met kind of person, and then the workout group guy, who is kind of like an insurance adjuster, trying to prevent you from getting much money or giving you much leeway if you're trying to work out of a problem.
So I don't know when I want to start in. So let me go ask you a few more questions about the Dentons case. Revelaze was a small family. Did I pronounce that right? Revelaze was a small family-owned tech company suing the biggest law firm in the world. What made you take that case?
Well, it was an attractive case because I thought the law firm had been guilty of malpractice when they said they had cleared conflicts, and they hadn't. I mean,
simple as that.
Yeah.
So,
I mean, think about it. A client comes to you and says, I need to sue a bunch of people. In this case, they needed to sue the Gap and some other people. Gap being the jeans importer.
Yep.
And all of a sudden, a month before the key hearing before the ITC, the Gap says, hey, you guys represented us in Canada, therefore you can't sue us now. That's a conflict of interest. And it is.
Mm-hmm.
Under any ethical rules, the modeled rules of the ABA, the rules of Ohio, the rules of Illinois, it's an ethical conflict. You can't represent one client against another. You can't do it.
So ultimately, so you won that case. What about the case against all the manufacturers who were doing so that were they both in that, or was that a separate trial completely?
No, it was a separate action. in the practice, we call it the underlying case or cases. So what happened is after they got disqualified, our financer wouldn't advance us sufficient money to continue the case, and so we had to settle cheap. And so we had an expert calculate what we settled for with versus what we would have settled for, assuming we won. We had other experts to say we would have won, and they calculated the damages. They had a range of damages, as I recall, something like 25 million to 75 million, and the jury found somewhere in the middle.
Okay, that's interesting. I'm beginning to see the logic here. So that case exposed something called Swiss Varine structure. Can you explain?
Swiss Varine is how I pronounce it, but who knows if I'm pronouncing it correctly?
How do you pronounce it?
Swiss Varine, but who knows?
Varine. Okay, I'm sure that
maybe I'm wrong
because I was just faking my way through it. So, can you explain what that means for someone who's hiring a?
Yeah, if you look at the different states and the different corporations, a corporation in Illinois is typically chartered by the Secretary of State, and they are then governed by the Business Corporation Act. That's the small corporate statute in Illinois. You can have a limited liability company, which then is established and subject to the laws relating to the limited liability companies. And different states have different companies. Well, Switzerland came up with this idea of having a varine, and it's just a name in some sense, like an LLC is a description of the type of company, or an S corp is a description of the type of company, or the business, small corporation is, and so on. So they have this varine, and it apparently allows for independent organizations that get together once a year and contribute to a marketing budget, and they do joint marketing, but theoretically they're separate corporations. And so they thought that this, at least they thought initially, that this insulated them. But you look at it and you say, well, what does that mean? That Dentons Canada could be on one side and Dentons US would be on the other side? I mean, that would mean theoretically Dentons could be on one side or the other of every lawsuit in the entire world, right? Without there being a conflict. And that's just not the law. It's not the ethics. And so it's prohibited. And so they were one of the new law firms that were organized as a Swiss Varine, but most of the other law firms that are organized that way have a formal conflicts of interest clearance procedure that recognizes that they are an association, and a conflict of one Varine is also a conflict for the other Varine.
Interesting.
So
So let me try some rapid fire, just lighten it up a little bit before we get into some fun stuff. And then we want to make sure that we go over anything that you're wanting to promote on here. But let's try some rapid fire. So best piece of advice you ever got from Justice Clark?
Ooh, that's a good question. It was more of a story where somebody had written him a letter asking him to do something. And in the letter, they said, "Oh, I'm sorry. I shouldn't have asked this. I don't want to make you do anything that you don't want to do, blah, 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 blah." And I said, well, that was nice that he said he didn't want you to do that. And the judge looked at me and said, well, he didn't tear up the letter, did he?
You just put a soft foot forward. First thing you do when you get a new case file.
Send the engagement letter and check for conflicts. Having won a big case involving conflicts, you can bet that's the first thing we do.
Favorite trail for hiking or camping?
I did the Durango to Silverton trail in the Colorado mountains with my son backpacking.
Oh, wow.
That was a nice trail.
Have you been on the Pacific Cascade Trail?
You recommend it?
Yeah, it's been a long time since I've been on it, but yeah, it's really it's rugged, it's beautiful. It's really, especially through Washington, the state of Washington, it's really fantastic.
Well, thanks for adding to my bucket list. I'm getting a little old. I'm trying to strike things off the bucket list.
Let's see. Huey Long or FDR, who was the better politician?
Huey Long.
Okay. He was pretty compelling. One book every business owner should read.
7 Habits is pretty good. How to Win Friends is pretty good. Think and Grow Rich is a little outdated. Actually, How to Win Friends is a little outdated, but if you can get past the old-timey references, I still think it's kind of a prisoner of its title, right? The title seems to be this manipulative thing, but I think really it's more of a philosophical treatise on how you could get the most out of life and how you can enjoy life.
Think and Grow Rich was the first business book that I read, given to me by my father, and it left a
Mine too.
lasting
When was
impression.
that?
Really?
Yeah.
Yeah, it left a lasting impression. Napoleon Hill. So you spent how many years writing a 720-page biography while running a law firm? What pulled you into Huey Long's story? It is fascinating.
Huey Long is a fascinating guy. I
Yeah.
mean, can you imagine being born in a little town of Winfield, Louisiana, population 3,000, in 1893 when they didn't even have telephones or electricity, and then becoming the second most photographed person in the United States, leading a following of 9 million people, and influencing significantly the policies and laws that were adopted under Franklin Roosevelt? It's amazing. It's an amazing story. So, but his primary, he lived during the Great Depression. That's when he was assassinated at age 42 in 1935. And his primary thesis was the United States was becoming an oligarchy. His theory was that we were approaching a modern feudalism where there would be a few rich people at the top and everyone else at the bottom would be peasants and serfs. Well, in my view, a lot of the World War II spending made inequality less of an issue because people had been unemployed or underemployed during the 30s. And all of a sudden, with the war breaking out, they were all employed in defense industries, and the government was spending a lot of deficit money to keep those people employed and give them the funds that they needed to do the work in the factories to win the war. And the rich people's money that they had was worth less because the government had pumped in so much additional money into the economy, and it went into the hands of the unemployed or underemployed. So if you look at the inequality statistics from the 1950s and 1960s even, there wasn't this huge disparity in wealth that existed. And Republicans and Democrats would argue about productivity and small adjustments to the economy. And
did you forget to pay your electric bill?
I guess that should be the first thing I do after a case. Hold on a moment. I'll be right back.
Okay, hang on just one second. I'll stand up while you get a break. So just in case there's some question, my motto is when a man falls down, kick him. Not really, but I couldn't resist. So go ahead. So you were talking.
Yeah. So anyway, so there wasn't much inequality in the 50s and 60s, or at least not as much as today. So Huey's idea that of this modern feudalism really fell out of view. But when we had the crisis of 08 and 09, and then books came out by Stiglitz and other Nobel Prize winners that we had an inequality problem, it brought Huey's ideas back to the forefront of my mind, and I wanted to check them out, see what the ideas said and see what he said about them. And so I did. I thought it would take, I had written a book for lawyers, and it had taken me 3 years to write. I figured, well, shoot, I'll write about Huey. It'll take 3 years, and then I'll be done. And that was in 2014. And the book didn't come out until 2024 or 2025. And
11
so it
years.
was a long process. And now I have a greater appreciation for what it's like to be pregnant than I ever did before.
So Carl Weiss, what's your opinion about the conspiracy there was he actually the one who pulled, is it really just, cut and dried, it was him, or is there something there in that part of the story? So maybe you can explain that too for
Yes.
our audience.
Yep. Huey Long was assassinated in September of 1935 in the state capitol that he had built, and he was shot by Dr. Carl Austin Weiss, a brilliant ear, nose, and throat specialist who lived in Baton Rouge. And there have been theories that Weiss did not shoot Huey, that he was shot by a ricochet from his bodyguards or maybe a deliberate shot from one of his bodyguards. And there were several books written articulating those conspiracy theories. They said, look, this guy spent a normal day with his family, fishing and swimming. He had scheduled a surgery for the next morning. There was no reason for him to go there and assassinate the senator. But something bothered him about Huey. There's no question about that. If he hadn't shot him, there were other conspirators who were plotting to kill him. And Louisiana is kind of a violent place in that respect. So
wasn't Carl Weiss's father a judge? And
yes.
And Huey had it out for, in Louisiana, he ran, a kind of a kingdom, and that judge didn't always do what he wanted to do. There's some bit of a backstory about that.
Sure. There's two aspects to it, right? Let's talk about the physical fact. Did he shoot him? And there were several books that came out. One by a reporter said, yes, Weiss shot him. Another by a guy named Zinman who said, no, Weiss did not shoot him. Another one by a guy named Reed who said, no, Weiss did not shoot him. And then there was even one by a Pavi relative who said Weiss didn't do it or he didn't think he did it. And those books served a useful purpose. They caused the state police to reopen the investigation in the 90s. And they found a gun which was stored with a relative of the state police. I mean, it wasn't handled correctly. And they found the pictures of Huey's clothes after his assassination. And for my mind, the pictures of those clothes closed the case that Weiss did shoot him, because it matched the holes in the clothes and the powder burns matched the testimony of the eyewitnesses who said Weiss came up and shot him. Mm-hmm. And so I think that closed the issue of who did it. Now, then there's the question of why he did it.
Right.
And his father-in-law was going to be the subject of a law to gerrymander him out of his judgeship. That was one theory. Another theory was that Weiss had spent time studying in Europe and had seen European dictators and thought Huey was a dictator and therefore had to be eliminated as a public service. And he did have the largest funeral of all time for an assassin. Over 2,000 people attended his funeral, including many public officials who were opposed to Huey, which, I think, whatever you think of Huey, I think that's terrible. But, and then there was a final theory that Huey was threatening to accuse his family of being part black, which at that time would have been an outrageous accusation. I think the balance of evidence is that he was not planning to do that. He was planning to run for president, knew he needed black voters in the North, and had actually apologized to a black newspaper in Baltimore for using the N-word and said he would try to be more tactful in the future. So I think accusing somebody of being part black in Louisiana in 1935 or 1936 would have imperiled his national political ambitions. But it could be true, or it could be that somebody told Weiss that he was going to do that, and Weiss took it upon himself to eliminate that threat, whether Huey intended it or not.
And so it's almost impossible to write about Huey Long in 2028 without readers drawing lines to contemporary American politics. Do you want to comment about that? I mean, you look at the populist movement and Trump, although he is completely different, and I don't get political on this show, by the way. This is an observational thing. Is a completely different animal, other than he's that populist part of Huey Long. Trump harnesses that same sort of dynamic.
Yeah. There was a review of my book in the London Review of Books that made a couple of points about that, where they said populism, it can be from the left wing or from the right wing. And typically, if populism is from the right wing, they will, in what one writer said, punch down at immigrants or Jews or blacks or some other marginalized group or persons. And then left-wing populists typically punch up Wall Street bankers or the rich people or things like that. And so you have an example of Huey as a left-wing populist who opposed tax breaks for the wealthy. I think in bottom, populism in many ways is more of a style than an ideology. Whereas most politicians are cautious and want incremental change, populism is more dramatic, and it's more far-reaching, and it's more extensive change is advocated. But I think it all depends, whether they know it or not, is on the American dream. The left-wing people will say the American dream is imperiled when the rich people have too much money or the bankers have too much control. And the right-wing people will say the American dream is imperiled when immigrants are stealing all of our jobs or committing crimes in our cities and preventing us from having a safe life, that kind of thing. And so there are these different aspects of the American dream that I think are in tension. So if you look at Huey then as a left-wing populist talking about the rich, and then you look at Trump as a right-wing populist talking about immigrants or migrants and things like that, you can see the two aspects of populism. But I think either side, either the left or the right, could actually benefit from reading my book, because I discuss what the sociologists call issue framing and mobilization and confrontation. And what I think Huey was adept at is framing solutions that were realistic and that met the real problems of people. And then he could sell the people on his ideas because his issue frames were good. And he obtained significant power just from the power of his own ideas. And I think that's something that should be emulated by other politicians today.
He was the consummate salesperson. So here's the big question: Broderick Crawford or John Goodman?
Crawford.
I agree. I thought that black and white movie was just outstanding. And so, just so everybody who's watching, there was a movie, and I think it was 1941. I was right about that time with, which is about Huey Long, and then of course he had the more recent movie with John Goodman. And so, if you watched the John Goodman one and you liked it, go back and watch the Broderick Crawford one. You'll love that. So okay, so you said
All the King's Men. That was the Broderick Crawford movie, and they remade that with Sean Penn in the Willie Stark role, and that was a big flop. Even though they had a great cast, it was a big flop. But Broderick Crawford was born to play that role, in my opinion.
Yeah, it took a dark turn in certain ways, though. But
yeah.
So why do you think he was so popular? And do you think that he actually had a shot at the presidency up against Roosevelt?
Well, it's an impossible question to answer with any definition. But
right.
Remember, he had 9 million people estimated in his Share Our Wealth clubs. And his assistant secretary said they had at least one member in every county in every state in the United States. And this was at a time when 20 million votes, maybe 21, 22, somewhere in there, could conceivably carry a national election. So if he had people who were willing to write in and become members of the Share Our Wealth Society, 9 million of them, if you can imagine them bringing 2 non-members to the polls, you've got a significant number of votes. Now, most of them were concentrated in the South, and he was probably stronger in the West than in the Northeast. But it's possible that he could have split the liberal vote with Roosevelt, elected a Republican, and then been in a position to run for president again in 1940 and win. And the weird thing is that would have basically duplicated what he did in the state of Louisiana. In 1924, he ran for governor, split the progressive vote. A conservative was elected, and then he won election as governor in 1928. So it's interesting that his career has these similar features at each stage of his career.
So you said, so I'm switching gears again. So you said your unwritten memoir would be called Confessions of a Trial Lawyer. Give me one confession right now.
I stole the title.
I should ask for two. After roughly 100 trials, what's the biggest mistake you see business owners make before they ever call a lawyer?
Well, I think what happens in a lot of cases that I see is two college friends, two work colleagues, two family members, they start a business and then something happens. Sometimes it's wildly successful and sometimes it fails. And if it's wildly successful, what I call the greed factor sets in. And one person thinks they deserve all the credit for the success and the other person doesn't. And then they have problems. And they don't always spend the money for a lawyer to draft an agreement that would protect themselves from the typical risks that all business people face: the risk of success, the risk of failure, the risk of death, the risk of divorce, the risk of somebody suing you for a personal injury or some such thing. So you have to examine all the risks, plan for them, and then decide what you're going to do about them. A lot of people, they go into business and they're one person or the other hands them an LLC agreement to sign, and they sign it without understanding it, without reviewing it, without asking a lawyer's advice on it. And in some cases, they don't have much of a choice in the matter if they want to do business with the person, but in other cases, they do. And either way, they'd be better off understanding what those risks are than proceeding naively into the future and then finding out that they don't have the rights that they thought they had.
So, what do you want the Patterson Law Firm to be known for 20 years from now? That's one of my last questions. Let me ask another question. You represented one of Dennis Hastert's victims in a breach of promise case.
Yes.
What was it like carrying that kind of story into court?
It was terrible, awesomely terrible, maybe. We didn't go to trial. It was ultimately settled, which saved the victim from having to.
Can you tell a little bit of the story? I should ask for more of the story first so that people who are listening can keep it.
Was the number three most powerful number three most powerful politician in the United States when he was Speaker of the House. And he was from a little town in Illinois called Yorkville. And when he was a wrestling coach before he went into politics, he was accused of molesting people. And one of his victims approached him years later and said, "Look, my life has been ruined, and you should pay for the harm that you've caused." And Hastert agreed to pay him cash, a certain amount of money. And there was such large amounts of money that the FBI discovered it and said, "Hey, what's all these cash withdrawals?" And he said, "Well, I'm being extorted." And they said, "Well, why don't you wear a wire and we'll catch the extortionist?" And he wore a wire, and when they listened to it, they realized that he wasn't being extorted at all. It was a settlement agreement, just like Stormy Daniels had or anybody else had. Keep things quiet. I'll pay you compensation for the harm that I've caused. And so then when that happened, he quit making the payments and we sued him for breach of contract.
Wow. So then he was pretty well. So what happened to his career after that? So you can kind of talk to that.
He ended up going to jail, not because of anything I did, but because of what he had done with respect to the money.
Right.
And I don't think he was ever sentenced. I'd have to check the record on this to be sure. I don't think he was ever sentenced for molesting a lot of people, even though that was widely understood that he had been accused of that. And but he settled the case and monetary payment, confidentiality agreement, and that's that.
As I remember, didn't he go by Denny?
Was it?
Yeah, I just vaguely remember that. So I guess I'm showing the number of birthdays I had with some of my references. Okay, so you've mentioned 3 ideas for your next book. Can you give us a hint about which one is winning?
Well, I'm thinking about the easiest one. The one where I could just have a few drinks and dictate some stories about what's happened over the last 45 years that I've been a lawyer. and call that Confessions of a Trial Lawyer, and then put that out and see if anybody likes it. So that's the one that's winning at the moment. I've got a couple of other books that have some methodological issues that I would have to figure out before I tackle the particular subjects that I'm looking at.
And then, so what do you want Patterson Law Firm to be known for 20 years from now?
Well, I think I'd like to be known as effective, efficient, and ethical trial lawyers. That would be.
So if somebody's listening to this and say, by gum, they sound like exactly what I need. I've got these problems. I need to talk to Tom. What's the best way to get in touch with you?
Either call us or email me at tpatterson@pattersonlawfirm.com. We have the Patterson Law Firm website. If you can't write that email address down, go to the website. There's phone numbers there. There's email addresses there. Get in touch with me.
Great. Now this will be out in about a week and a half, this podcast. Thanks for coming on the podcast, Tom. I really appreciate it.
Thanks for having me. I enjoyed our conversation.